Assalamualaikum and hi and good day to Media Farshima and to everyone who is watching our video presentation. So our group consists 5 people which is me, myself, Mufitra Fatisha, Nur Fatih Kislina, Hanisa Fatini, Nur Artika, Mama Ali Anan and Shakir Shadi. So we have been decided to choose one of topic in relation to issues of Malaysian constitution and our main topic, and we have choose our equality before law as our main topic.
Concept of law. Law is defined as the principle and regulation that are set by the state and legally enforceable. It must be obeyed by the citizen or they will have to face the legal consequence. The purpose of law is to regulate the society and protect the right of people, to resolve conflict and to attain justice. Justice is attained by determining what is right or wrong and maintaining the fairness and equality. According to the prominent legal jurists, they define law as A. Law is the body of principle recognized and applied by the state in the administration of justice. B. Law is a command set by the superior being to an inferior being and enforced by sanction. The superior being is the state and the inferior being is the individual. The sanctions are wide and include imprisonment, fine, injunction and decrease of specific performance. C. Law is a rule of civil conduct prescribed by the supreme power in a state commanding what is right and prohibiting what is wrong.
Next is facts about legal issue of Serenity Campaign versus Government of Malaysia. Several Malaysian moms who are married to foreigners and have children outside the Federation legitimately requested a declaration that their children are citizens by virtue of their marriages of law under Art 14 Clause 1 Subclause B, read with the second schedule and as 1 Clause C of Part 2, in much the same manner as children who are born outside the Federation to Malaysian fathers are entitled to citizenship. The plaintiffs argue that this contested clause should be interpreted in a way that is consistent with the Article 8 Clause 2, which forbids gender discrimination in all laws. In addition, the COVID-19 pandemic caused them to face difficulties in returning to Malaysia due to barriers to the entry of people non-citizens. Then, for legal arguments, the plaintiff argued that the disqualification of reserving the citizenship of her child because of the gender is against the Article 8 Clause 2 of Federal Constitution and violated her constitutional rights of gender and human dignity. The defendant argued that it is not relevant for the plaintiff to receive the citizenship of child because it is against the 14 Clause 1 Subclause B, second schedule Part 2 of Federal Constitution. It stated that the child's citizenship will follow the father's lineage and that the father's citizenship must be the Malaysian one. The word father refers to father only and is not intended to include the mother.
Today, I will explain about analysis of our chosen cases, which is Serenity Campaign against Malaysian government. Based on Section 8 Clause 1, that every person shall be equal under the law and have equal protection of law. Authorized that the plaintiff bring an action on the government for not approve the citizenship application of her child because the child has no right in receiving his citizenship in Malaysia. Therefore, the plaintiff think this is a discrimination for overseas born. According to Section 8 Clause 2 Federal Constitution, the article says, except as expressly authorized by the Constitution, there shall be no discrimination against citizens on the ground only of religion, races, descent, place of birth or gender in any law or in the appointment to any office or employment under a public authority or in the administration of any law relating to the acquisition, holding or disposition of property or the establishing or carrying on of any trade, business, profession, vocation or employment. Based on this case, when campaign against Malaysian government, the plaintiff married a foreigner and the citizenship of the child cannot get the Malaysian citizenship because according to Section 14 Clause 1 Subclause B of Schedule 2 Part 2 Federal Constitution, the section said that the word father refers to father only and is not intended to include a mother. This means it does not include Malaysian mothers who are married to a non-Malaysian citizenship from passing on their citizenship status to their children who were born outside Malaysia. Following the Section 8 and 14 Clause 1 Clause B, the court suggests that this is not a discrimination since the act of plaintiff is against the law of Federal Constitution and does not apply to any of the articles, which is Article 8 and 14 Clause 1 Subclause B of the Federal Constitution.
For the judgment, the High Court of Malaya at Kuala Lumpur held that it was relevant for Suryani, the plaintiff, to bring up this case to the court. This is because, referred to Article 8 of the Federal Constitution, equality is stated to be all persons are equal before the law and entitled to equal protection of the law regardless of status, gender, race, and more. But after a few months, Malaysian government has filed a request to appeal the court decision that overseas born of the plaintiff was qualified to get Malaysian citizenship. It is because The court decision has against the Article 14, Clause 1, Subclause B, Second Schedule, Part 2 of Federal Constitution.
I will explain about legal case of Nur Fadilah binti Ahmad Saikin versus Syed bin Basirul and ORS. The fact about this case, the defendant were at the material time education officer of the education office of the Hulu Langat district, in charge of employing person interested in the GSTT position of Hulu Langat district. The Ministry of Education tried to overcome the problem of shortage of teacher in Malaysia by employing untrained teacher, also known as GSTT. The Ministry had previously issued a letter of approval or warrant to all state director of education authorizing them to select and employ GSTT. The plaintiff had applied to PPDHR to be employed as a teacher. The plaintiff had received a call requesting her to attend an interview at PPDHR. On the day the plaintiff attended the interview, she was asked to fill out certain form before the interview. During the interview, the plaintiff was not asked whether she was pregnant or not. The plaintiff received a text message from PPDHR officer. The plaintiff was given a memo penempatan or placement where it was stated that the plaintiff will be posted to Sekolah Menengah Perasaan Tinggi Kajang. The plaintiff and a few others were then given a briefing of terms of service of employment, such as requirement to give 1 month's notice registration. The plaintiff was asked to report for duty immediately. The defendant asked if anyone is pregnant. The plaintiff and 2 others admit they were pregnant. The defendant then withdrew the placement memo of the plaintiff. The plaintiff, through her husband, wrote several emails to the ministry requesting for an explanation. The ministry, on behalf of the defendant, replied the ministry relied on the circulars to say that a pregnant woman cannot be employed to the GSTT. The plaintiff filed the originating summons against the defendant.
So today I'll be giving a brief about the legal arguments of the second case, which is Nur Fadilah versus the government. So let's hear and see the arguments between them. Okay, first let's hear the argument from the plaintiff. The plaintiff, which is Nur Fadilah, argued that the refusal to employ her as a temporary teacher is very unlawful and violated in breach of constitution right. The Hulu Langat district education officer, which is the defendant, refused to employ her as a temporary teacher when she became pregnant and revoked her appointment in 2009. Meanwhile, the defendant, which is Mr. Chayet, argued that a pregnant woman cannot be employed to the GSTT, which is temporary teacher, because of these 3 causes, which is the first one is the period between the time of delivery to full health is too long. Secondly is a pregnant woman as a GSTT may not frequently be able to attend to her job due to various health reasons. And last but not least is when she gives a birth, she needs to be replaced by a new teacher who will require further briefings.
So I will continue the presentation for the analysis. From the section 8 clause 1, authorizes the plaintiff bring action against the government after Hulu Langat district education officer revoked her employment as a temporary teacher. The plaintiff applied and obtained employment as untrained backup teacher, but after plaintiff admitted that she was 3 months pregnant, her position was revoked and withdrawn by the defendant on the sole ground that she was pregnant. According to the section 8 clause 2 of the Federal Constitution, state that except as expressly authorized by this Constitution, there shall be no discrimination against citizens on the ground of the religion, race, descent, place of birth, and gender in any law or in the appointment to any office or employment under the public authority or in the administration of any law relating to the acquisition, holding, or disposition of property, or the establishing or carrying on of any trade, business, profession, vacation, or employment. Following the Section 8 of the Federal Constitution, the court suggests that this act of a defendant was tantamount to the gender discrimination and thus against the Article 8 Clause 2 of the Federal Constitution. Thank you.
after we have done a see the analysis of the case, which is how the court apply the rules and section to this case, the High Court finally gives its final decision. So apparently, the High Court held that it was not relevant whether there was an agreement between the defendant and plaintiff or binding contract, as the defendant's decision interfered with the plaintiff's right to be employed, which is contrary to the Article 8 Clause 2 of the Federal Constitution, which provides there shall be no discrimination on the ground of gender in the employment of any employment under public authority. The High Court declared that using pregnancy as a fact, that in employment is a form of gender discrimination under the nation constitution, and the government have violated Article 8 Clause 2 of the Federal Constitution, which protects against the gender discrimination. In Article 8 Clause, the High Court adopted the CEDAW's Commission of Elimination of all forms against a woman definition of discrimination against a woman. This means that there cannot be a direct and indirect discrimination against a woman. It was a basic biological fact that only women have the capacity to become pregnant, and therefore discrimination based on pregnancy is a form of gender discrimination. The High Court finally awarded the plaintiff the sum of 40,000 for breach of her constitutional right and damages. Thus, the court recognized that the plaintiff is entitled to be employed even if she is pregnant.
Like that, Article 8 Clause 1 of Federal Constitution, equality before law is important because it ensures that all policies, regulations, and laws are applied equally and do not have any discriminatory effect. And it prohibits law from unreasonably and unfairly favoring some group over others or randomly discriminate against persons. Therefore, the principle of equality before law is very crucial in maintaining the equality in our society.